A case where the client comes into the office and signs the will, and the will is witnessed by the secretary, and for some reason the lawyer doesn't sign it at that time, puts the will away. We've got a will with one signature. That can't be saved by the present statutory provisions. Now, Al Brule told a story a long time ago, which I've remembered, about that type of thing which actually happened. The solicitor was called and told that a client had died and that he had the will. He pulled it out, was horrified to find that there was only one signature on it. It was his secretary's. He did know that he had been in the presence of the testator when in the office. He remembered the testator being there to sign the will. So he did what any solicitor would do, I guess. He went up to the funeral home, and in the presence of the testator, he witnessed the will. Seems to be a practical solution to the problem. Now, the cases we've talked about deal with problems, negligence in relation to the execution of the will. And as Brian has alluded, I don't think that we're going to be limited to cases involving the negligence in the execution of the will. And we'll probably very shortly be facing claims dealing with negligence in the preparation of the will. Now, I've given a number of examples. There are 4 examples here. I'm going to refer to them briefly. The first example I call the failure to use reasonable skill example. Substandard drafting requires court application because of an obvious ambiguity in the will. I don't think it's unreasonable to expect that a court one day is going to say that there was a duty to use reasonable care. You breached that duty, and the beneficiaries have suffered damage by the costs of the litigation. And Mr. Solicitor, who drew the will, you're going to pay for that. And this morning, Mr. Collins Williams mentioned to me that there is an old Ontario case that I haven't been aware of. I think a judgment of Mr. Justice McCrur, where solicitors took a will to court for an interpretation. They were the solicitors who prepared the will, and the judge was incensed that they should be bringing their own will to court for construction and awarding costs against them, and this was a long time ago. Second example, I'll call the failure to advise of the alternatives and consequences. Failing to provide for an obvious dependent. Again, we could result in a dependence relief application, cost to the estate, and maybe the solicitor is responsible for that. The solicitor can protect himself against that liability by asking the relevant questions, taking down the information, putting memorandums in the file, or maybe confirming letters to the client. And I suggest to you that if you don't ask the questions or you don't have the information in your file, if it's a choice between you and the beneficiary, and you ought to know better, you'll probably pay. The third example is the failure to advise of a risk example. Now, there are probably very few lawyers who advise clients to make sure that your executor is honest. But let's face it, the executor has title to the client's assets and can run away with them. And if you pick somebody who is questionable, if you don't direct that question to the mind of the testator, hey, is this person really somebody I can trust? He may know the family, he may be good at managing money, but is he trustworthy? If you don't ask the question, there could be problems. There are easy ways of avoiding the problem, even if the executor may not be 100% trustworthy, and the client wants that person to be appointed, you can name a co-executor, and that minimizes, if not eliminates, the risk. The fourth example, I'll call the unanticipated result example. And this is a trap that we could fall into very easily. We have the residue of the testator's estate divided equally between my two brothers. What he really meant was to divide the residue of my estate equally between such of my brothers as survive me. Because the operation of Section 31 of the Succession Law Reform Act, which is the statutory substitution, or the anti-lapse provision. In the example here, the wife of B, who predeceased the testator, is going to take his share of the estate. And I've also assumed that it's obvious that T and B's wife don't get along for whatever reason. Now, I'm not saying in these examples that the solicitor is going to be liable in every case. May not be liable in any case. But I am saying that there's a risk. A risk that he needn't have run. Now, if you want to run the risk, that's fine. I just want you to appreciate what the risk is. Now, let's look at some areas of potential problems. Status and capacity. Well, that's been talked about quite a bit today. I think it's difficult to imagine how a solicitor could be financially responsible if the will was found to be invalid because the testator lacked capacity. If he couldn't make a will, nobody really was hurt anyway. But there may be a court application to try and determine that validity. And there may be costs involved, and if the solicitor hasn't been up to scratch, he may have to pay those costs. Even if he doesn't have to pay the costs, he's going to be involved in a trial as a witness. There's expense, there's delay, there's aggravation, and there's also his reputation at stake. Now, in terms of status and capacity, one of the easy things that you can do is make sure that the client is old enough to make a will. General rule has to be 18. There are exceptions where the person can be younger than 18. But if you make a will for a 16-year-old, you may have wasted your time. You've got to make sure that there's a sound disposing mind. Mike has talked about the test. I've cited another form of test, which was from the case of Murphy and Lamphere. It's a 1914 Ontario decision. There is a footnote which refers to a later case from which the quote came, but originated in Murphy and Lamphere in 1914. Must know the nature, extent of his property, and the nature of claims of those who he's excluding. The test isn't any different from the Banks and Goodfellow test, but just another way of saying the same thing, really. I agree with Michael that if there's any doubt as to the capacity of the testator, that you're probably best to make the will, keep copious notes. It really isn't up to us to decide whether or not this person should be refused the opportunity of having a will. If, however, you come to the conclusion that the person just doesn't have mental capacity, don't prepare the will, but make notes. Because the guy in the next office may prepare the will, and you may be called as a witness anyway. You may look pretty good if you have a good set of notes. Personal instructions. Always meet with the testator. Back in 1970, the Ree-Worrell case was decided, and Brian Snurr has made reference to that about some scathing comments about a lawyer, and I've reproduced much of that. I suggest that you read that over and see whether you might fall into some of those traps. The last paragraph, I think, is worth noting. I quote, "It seems incredible that a competent solicitor, the head of a respected firm, would act in this manner. It seems more incredible that he gave no indication in the witness box which would indicate that he realized he'd acted improperly." Now, you're going to have to decide when and where you're going to meet with the testator, if at all. Many people will tell you that you better have him into the office and take instructions. I'll tell you that that's not my practice. Right or wrong, it's not my practice. I usually speak to the testator on the telephone because I find I can get the information more quickly over the phone than I can when he comes into the office. But it is my practice to meet at the time of execution at the office. Usually, if that's not possible, I'll have to go out to the testator or send somebody from the office who can do that. But I meet with them at least once. Now, obtaining the relevant information, we've been had in previous lectures an indication of what we should talk about. Certainly the words relevant information have to be underlined. You may have heard the story of the balloonist who left the West Coast, decided to go across the continent by balloon. He got lost in a fog about 2 days into the trip and decided that he would come down and find out where he was. And he came down to a height of about 50 feet, and there was a clearing. It was over a little house in a rural area. And he spotted a man down walking along the roadway, not far from the house, and he yelled down to him, "Where am I?" And the man yelled up, "You're 50 feet up in a balloon." He said, "Well, I know that, but exactly where am I?" "Oh, you're over the Jones farmhouse." Thank you. By any chance, are you a chartered accountant?" And the fellow on the ground, somewhat surprised, said, "Yes, I am. How did you know?" And he said, "Well, your information was absolutely accurate, but totally useless." The little story, I think, points out two things. The information you get has to be relevant. More importantly, you've got to ask the right questions to get the right answers. Now, if you were preparing a shareholders agreement for somebody, you'd go into some depth of finding out about the ownership of the shares and where they should go upon death, and how they're going to be treated. I don't think a will should be treated any differently. Get the facts. I've listed a number of things that I consider the relevant information, and I don't propose to go over them again now. Obviously, knowledge of the law is an important area. We can't prepare wills if we don't know anything about the Succession Law Reform Act. It was the absence of knowledge of the law in the Whittingham and Crease case that was the downfall of the solicitor there. And I've enumerated a number of principles, again, the same ones that Brian and Michael have referred to. Interestingly, there was a case in 1961 in California, a solicitor's negligence case of Lucas and Ham, where the solicitor was sued by a beneficiary in negligence. Back in 1961, the court in California said there was a duty of care to the beneficiary. 1979 was not the first time that this decision had been, or this principle had been espoused, first time in Canada. But went on to say that perpetuities legislation was so complicated that a reasonable lawyer wouldn't be expected to understand it anyway, and there was no liability to the solicitor, who had drafted a will in violation of the rule against perpetuities, and a gift to a beneficiary failed. They didn't have a wait-and-see rule in California at that time. I don't know if they do now or not. There might be more than one or two here who might offend the rule from time to time if they're not careful. Now, obviously, we have to keep up to date in changes in the law as they occur. I've enumerated a number of changes in the Succession Law Reform Act which differ from the old law under the Wills Act. Changes are important because problems can crop up in the most unusual ways. For example, if you refuse to do a will for a 17-year-old, the person had lacked the sufficient age for a will, and that person died leaving substantial assets and there was an intestacy. And a letter could be produced to show that that child had specific intentions of where the assets were to go. Maybe that document couldn't be admitted to probate, but let's assume too that that 17-year-old had been married. Now, today a 17-year-old who has been married or is married can make a will. Query whether you might be responsible financially if you had refused the opportunity to make a will. Now, I don't propose to try and deal with any of the tax changes. I've listed some of them there. I haven't mentioned the Income Tax Act for the obvious reason we have so many budgets during the year that you can never know what the state of the income tax law is. With greatest respect to Jay, who undoubtedly knows far more than I will ever know on it. But certainly keep the Income Tax Act in mind. Now, Rodney Hull is a colleague of mine at Willydale, and many of you will know his name. He suggests that solicitors also have a responsibility to advise clients as to changes in the legislation after the will is made. You may have made a will for a client 5 years ago, and there's a legislative change which has an effect on the plan that's provided. Now, Rodney and I don't always agree on everything, and this is one area that disturbs me greatly, because to what extent must there be a legislative change before you must review it with your client? For example, in 1978, I believe it was, the Income Tax Act was changed with respect to RRSPs, that if a person died owning an RRSP, there could only be a rollover if the RRSP proceeds went to the spouse. Prior to that, there could be the possibility that children could purchase income averaging annuities with that. Now, I certainly didn't review all my old wills to see whether there was provisions dealing with RRSPs going to non-spouses. I certainly, while I keep an index of wills, I don't index them by subject matter in terms of RRSPs or Income Tax Act. In 1978, the definition of dependents was expanded under dependents relief, include common law spouses. I believe that was an extension. I certainly didn't review my old wills to see whether perhaps somebody was cut out that may now be classified as a dependent. There was also a change in the statutory substitution provisions in Section 31 of the Succession Law Reform Act. It used to be that in order for the statutory substitution to apply, that the beneficiary had to die leaving issue, or issue and wife. Now it's issue or wife. Would that have an effect on his intention? Well, I hope Rodney is wrong. But I pointed out to you that perhaps it's a risk. I guess it's a risk that I'm prepared to run, at least for now. Ambiguous drafting. Obviously, we have to do our best to put across a will that expresses the client's intention. It's got to be clear. A number of years ago, I searched a title in the county registry office and came upon a will which I will always remember. It will never have to go to court to be construed, but I think it was a good example of a misplaced modifier, where the testator said, "I devise to my dearly beloved wife, if not previously disposed of by me, my lands and premises I wish I'd kept the instrument number from that, but I actually saw that. Certainly, too, in clear and unambiguous drafting, you better make sure that the executors have the powers to do what they need to do. And two of the things that perhaps are very important to consider where there's going to be more than one executor is, should there be action by majority? If you don't put a majority clause in, the executors are going to have to act unanimously. And should there be a power in there which would allow an executor to purchase estate assets? In many cases it won't be needed. In some cases it could be crucial. Delay. How long should a solicitor be allowed to prepare a will before it runs some personal liability? Rodney Hull stormed into my office yesterday. Excuse me. The day after I received my lecture back from the Law Society. And he wondered about a situation where a client had consulted him was to be a beneficiary under a will of a elderly woman who was in a nursing home with a health problem. And the woman had given instructions not to a solicitor but to a trust company, which is in the business of preparing wills and estate plans and perhaps has the same duty. And nothing was done in a month, and the client died. And the beneficiary, or the person who consulted Rodney Hull, wasn't a beneficiary under the intestacy provisions. And it may not go to court, but it's ticking over in Rodney's mind, and Rodney loves to go to court. And so there's a risk. And I don't know where that dividing line is. I think you have to judge each situation on its own facts. If you have an elderly person who's in poor health, I think you better spend less time getting the will prepared and signed than if it's a 35-year-old friend. Now, in terms of execution of wills, we've looked at Whittingham and Crease and Ross and Connors. There are sections in the Act which specify what you must do to make sure that it's properly executed. I do suggest that you have only one copy of the will signed. There are people solicitors who still have more than one signed, and there are a number of reasons. A will is a valuable document. It's like a promissory note, in effect. It will deal with the disposition of a lot of property, and if you were preparing a promissory note for a client, you wouldn't have two of those signed floating around. You'd make a conformed copy for somebody for information purposes, and I think the same is true of a will. It's particularly true if the client is given a signed copy to take home, and if the client decides he wants to revoke his will and tears it up, throws it out, beneficiaries come along later and ask the lawyer if he has the will, and he looks in his vault, and yes, there's a signed will, and it goes to probate. Maybe that the testator's intention of revoking that will are completely frustrated just by there being a second signed will. Again, on execution, if at all possible, get the client to come into the office and sign it in your presence. And if the client can't come in, you go out or have some responsible person go out to see that it's properly executed. The costs to you may be substantially less in the long run. If you're going to send out a memo, or if you're going to send out the will, as Brian said, make sure that you send out a detailed memo of what the instructions are and the warning of what happens if it's not followed to the letter. Now, avoiding the malpractice action. Much of what I say will be a regurgitation of what I've already said. Start with the assumption that you're going to be challenged. If you do that right from the outset, you'll probably cross the T's and dot the I's and won't have a problem. Continually upgrade your skills. Adopt a routine or standard procedure. If you don't have checklists, you're better off to get them. and follow them regularly. Update the checklists as legislation changes or cases are decided that give us new principles. Mike Fitzpatrick has a list in the back of his material. Rodney Hull has recently done an article in the recent edition of the Estate and Trust Quarterly. It's volume 6, issue number 1. And he has an article in there about taking instructions for wills and has a checklist in it, which is quite a good one. It's not his checklist. He credits Jim Wardlaw with the checklist, but it's quite a good one. Now, once you've got the information, don't just keep it in your head. Get it in your file. Write it on your checklist. Have a memorandum. Dictate a memorandum. Better still, write a letter to the client. And believe it or not, this is my practice. After talking to the client on the phone, I'll write him a 3 or 4 page letter. And it will set out that I've obtained certain information from him and that I'm relying on the accuracy of his information. And it will list his family and dependents. I'll ask him who is financially dependent upon him, even outside his own family. It may be that people are looking after brothers or sisters or nephews or nieces, even friends. The next section deals with his assets, and I'll recite what his assets are. And I even set out in there certain explanations as to why administrative clauses are there, the fact that you should have faith in the honesty of your executor, and so forth. Now, that seems like a lot of work. If I had to sit down and do that letter from scratch right now, it would take me a long time, but I've been doing it over a number of years, and I've been improving it each time, and I have a precedent which I work from. And I feel there's a big advantage to having that letter which goes out to the client, and that is, if I have mistaken some of the information, the client has the opportunity of correcting me, and my plan won't be based on the wrong information. If the decimal place goes in the wrong parcel, as it did in Al's material, at least there's the opportunity of correcting that, and that may have a big effect on the plan. Not everybody will do that, or want to do that, or think that it's necessary, but consider whether it might be useful. Retain all your notes as to testamentary capacity. What I don't do is give the client in the letter my assessment of his testamentary capacity. I'm afraid he would write back with his impression of mine. Okay, those are a lot of things of what to do and what not to do. How can I do it without losing my shirt? Well, I think it's about time that we started saying, why are we doing $50 wills? Maybe, as I suggested earlier, we could afford to do them because we had no liability on them. We may think of them as lost leaders and we'll do the will now and we'll get the estate later, but that's not happening as much as it did 20 or 30 years ago when there was a loyalty to the solicitor. At least I assume that's true. I haven't been around that long, Al.
It's changing.
People are more mobile. They know more people who are lawyers. Children are lawyers. So maybe we shouldn't be doing wills on a lost leader basis. I suggest that we don't. If you're going to run a risk, you better not lose money while you're doing it at the same time. Now, maybe one way you can recoup some of your losses if you still want to do it as cheaply as you can, because if everybody in this room decided that they were going to charge a minimum of $125 or $150 for a will, there's going to be another 8,000 or 9,000 out there who aren't here today, who may do wills, who are going to be doing $50, and we're going to lose some clients. So there's a risk there too. If you want to try and recoup some of your losses, suggest you need more than a will, you need a power of attorney, because a will's only going to look after you if you die. But if you're in a coma or you're no longer mentally capable because of age or infirmity, power of attorney can look after you. And powers of attorney are pretty easy to do. So you can do a couple of powers of attorney, charge an extra $50 for two, and recoup some of the time you've lost in the will. And I don't think that's soliciting, because what you're doing is you're planning that person's estate. And planning during life is every much important as planning for death. Okay, storage of wills. I suppose that most of us store wills. And I don't imagine very many of us have had loss experiences. Stop and think for a minute, what if I had a fire? What if all my wills were destroyed? First of all, does my errors and omissions insurance protect me? And is this part of the practice of law? I don't know the answer to that question. I spoke to an adjuster at Maltman's, and he surprised me actually by suggesting that it may be part of the practice that solicitors do that. I thought he would say no, it wasn't. Don't rely on that statement. Where are you going to store them? A lot of people store them in safety deposit boxes. That can get pretty expensive if you've got 1,500 or 2,000 wills. Some people store them in straight filing cabinets, and I think that they're running a big risk there, and just as long as they appreciate that risk, that's fine. I think as a minimum that should be in a locked, fire-resistant cabinet. That's just a personal opinion. I think he's got a duty to use greater care in keeping that will, which is a valuable document, than he does in keeping his files, which are just old information records. Certainly he would have the same duty in my mind as he would for keeping stock certificates and so forth. And stock certificates can be replaced. A will may not be able to be replaced, although if you have a copy, you may be able to prove the copy in solemn form. Now, we're never going to be able to guarantee that there won't be a loss in our wills no matter what system we use, so I've outlined in the material some steps that you might take to minimize the risks in the event of loss. If you keep an index, you can, if you find out there's been a fire and a number of wills are destroyed, if you can look up in your index, you can check against the wills that you have and you know who you have to contact to replace. It is surprisingly cheap to microfilm wills. I had occasion to look at doing 1,500 wills, and it was going to cost about $500. And you end up with a couple of rolls of microfilm, which can go in a safety deposit box, and that would be pretty cheap. Didn't do it, but I looked into it. Finally, just on the issue of a solicitor acting as trustee. Many of us are named in wills either as primary or alternative executors. Keep in mind that when you act as executor, you're not performing a solicitor's function and you are not covered by your errors and omissions insurance. If you wish to have coverage for that, you better try and get in touch with your agent and arrange your own. Now, just in conclusion, really this, as in any other area of law, is an application of common sense. Identify the risks, protect against the risks, or know what risks you're going to run. Remember, a will is nothing more than a dead giveaway. Make sure it's the testator that's doing the giving. Thank you.
Thank you. Thank you very much. Now, I don't know whether or not you people have another 5 minutes or so, and we won't hold you, but there are some rather interesting questions I think we can answer very quickly. And those that we can answer, I think members of the panel might be able to stay for a few minutes. But if you want to hear some, because I think they're all right, we can maybe go ahead. And I'll answer 5 or 6 in 2 minutes. It says, we've used Xerox wills produced after cutting and pasting and then sign it. Would the circuit court accept this? And my answer to that is yes, but I do two things. I do a memo setting out that it's not an original type thing, but the way it was done, so it's there so they understand. And secondly, what you can do, and now that our Succession Law Reform Act provides that you can do an affidavit of execution immediately after the signing of the will, put a little clause in the affidavit of execution that it has been signed on a Xerox produced and it is an original, and then I don't think you'll have any trouble. The other part of the question was that if taxes and nature of assets are changing and therefore wills should be changed also, what ethical steps can lawyers take to promote their clients to sign new wills and make the corrections? And that's just what we were hearing about in the difference of opinion. Well, let me tell you the Law Society's opinion now. Up until 2 years ago, it was quite standard procedure as far as ethics were concerned that you couldn't go to anybody and say it's time to bring up your will up to date because you were looking for new business, and lawyers don't do that. That's a no-no. However, that's now been changed, and I don't think it's ethically wrong for any solicitor to suggest to a client that you make a new will and take into consideration new changes in law. Whether it goes so far, apart from the Law Society's ruling, that there's a onus on the solicitor to do so, and as Gordon said, he didn't think so, and I don't either. However, it depends on how much knowledge you're seized of and whether or not at the time of making the original will you may have given an undertaking to the client to revise his will or alert him of any income tax changes. In fact, in some law offices, I know they do just this, that when there are budgetary changes, they just simply mail out those affecting wills or estate plans to their particular client. It's rather expensive, and I think you would only want to do so in the more affluent ones or where they would make a big change. Now, another question involves a solicitor being appointed as an executor under a will, and two parts to this to summarize it. What happens if he becomes incompetent before the person dies? Can another partner take over? And it suggests a power of attorney, which absolutely not. And secondly, what happens if he becomes incompetent or so after death? Well, it's just a matter of providing an alternate executor, and a clause simply saying, I name A as my executor, but providing that he is unable or unwilling to act, predeceases me, then I appoint B, another partner, or you don't have to identify that other partner. You can say the senior partner in the firm, as long as the court can decide who might do so. And I think there are precedents for that in some of the wills books. One on multiple wills, it says, is there a need, can they be avoided if you use the international form of will? And the answer to that is simply yes. There's a provision now under Succession Law Reform Act to use an international will. My only argument against the international will, I guess I have two of them. One is that if you're taking a will that's completed in an international form and you're probating it here, it's going to take some time. By the time you get to another jurisdiction, it may take some time to get it done there, and you have to inquire, first of all, whether it would be valid there. And secondly, if it's in the English language, let me assure you that if you have a condominium in Spain or something, you're going to have a lot of trouble getting that done in an English form will, even though it may be an internationally approved. So I still think the multiple will is best. Now, coupled with that, a question, does a properly executed Ontario will convey a Florida condominium? And I can say yes, today it does. Again, you have the delay. But 4 years ago it wouldn't, because in Florida 4 years ago you needed 3 witnesses to a will to convey realty. That's now been changed. But there's some still, I think 11 or 12 states in the United States require 3 witnesses for realty. The same as only a couple of years ago, a holograph will was valid in Ontario if it was done by someone in Quebec, but it wouldn't convey realty, it would personalty. So just be careful whenever you're dealing with property in a foreign jurisdiction. The last one I have here, what is the latest on the new surrogate court tariff for suggestion of fee schedule? And all I can tell you is I think that the Rules Committee recommended that it all be done on a quantum merit basis. That got up to the Attorney General's Department, and as I understand, Gordon, you may know more, it's been sent back now to the Rules Committee for further consideration. So maybe we have some allies in the Attorney General's Department. Brian, if you have a couple, and then we'll go.
Well, I've quite a few, but rather than cover the number I have, I just want to deal with one only because it was repeated 3 times. And this was a question about, as one person put it, views of an anti-hassles clause in a will, along the lines of if any person shall attack any aspect of a will, of my will, I presume, or his entitlement, then he gets nothing. This is tried very, very frequently, and it's a nice try. However, the courts, anytime they've looked at these, as you probably know, have tried to find ways around them. They don't like them. They have sometimes found them void as against public policy. And there is a recent case, it's not Ontario, and it's not in the ETRs, I think it's in the DLRs, dealing with this, about a year old, where a court, I think out west, did reject the provision as being contrary to public policy. So I don't think the, as this person well calls it, anti-hassles clause is going to help you in terms of avoiding litigation. Now, yes, I think Mr. Collins-Williams has a few comments, and please, if you have any further questions, Al and I think the rest of the lecturers will stay around for a few minutes or as long as it takes to dispose of any questions you have.
I'm going to take 30 seconds to say thank you to Al and Brian and their very able faculty. I know you want me to say thanks, and I say thanks for the losses had.